an expert in copyright law, you hire a copyright firm. You have an employment case, you get an employment lawyer. And a state court business dispute, you get a state court business litigator who knows the state judges. And when you are in an appeal on one of those cases, who do you go hire? No one. That's right. You continue on with your existing lawyer because this is just the next phase of a case, like going from the pleadings to discovery, right? Wrong. You just made a big mistake. Data shows that around 90% of all appeals are lost in federal appellate jurisdictions. In experience, it shows almost 90% of all cases continue with the same lawyer from the trial court to the Court of Appeals. Coincidence? No. Why does this mistake happen? Appellate courts may look like trial courts. The judges are wearing robes, you file your briefs electronically, you've got law books on the courtroom table, and you have a courtroom clerk you check in with. There are flags behind the bench and the judges, and then you sit at counsel table. But don't be fooled. They operate with a completely different center of gravity to the trial court. Almost every assumption you make about litigating in the trial court is off base when you go on appeal. And when you are going on appeal, whether to seek a reversal or to hold the ground you won, you need to talk to a lawyer who knows that court, its governing poll stars, and its center of gravity. If you want to win on appeal, you must fundamentally recognize that you need to speak to an appellate lawyer, one with the right skill set for this phase of a case. Because at the end of the day, as we're going to explore today, an appeal is not simply an extension of what you've done before, and it's not even close. I've been an appellate litigator for almost 20 years now. I clerked on the Federal Court of Appeals, and I teach a federal appellate clinic at the University of California, Irvine School of Law. I've litigated upwards of 100 appeals for my clients, many with my students, where I taught them the appellate litigation process step by step. As an appellate litigator and clinical instructor on appellate law, I have, through sheer experience, developed multiple critical insights into the appellate process, born from the rough experience of the appellate trenches and the need to clinically teach how to do the job. As an appellate litigator brought in by sophisticated general counsels to look at trial court proceedings, I've repeatedly seen where the process breaks down if appellate counsel is not retained. There are myriad key insights, and in a brief overview, not everything can be addressed. But over the next half hour, I am going to share some fundamental insights with you, such as the currency of credibility in structuring your appeal, knowing what fences exist to control your audience of appellate judges, and how to get over those fences, and some of the insights on structuring an appellate oral argument. So, before we explore how to win on appeal, I want to discuss with you the staggering differences between the two court systems, trial on the one hand and appellate on the other hand, so that the insights we then address have a proper context. This is critical because litigation in the trial court is not the same as litigating an appeal. And to understand this context, we need to briefly think about the different court systems. First, when you file a lawsuit, you are assigned to a judge and you can do your intelligence on the judge to understand that specific judge's proclivities, leanings, writing style, preferences even. You tailor your written product to a known entity, in other words. You have a target. But on appeal, you don't know your audience at the time of writing that appeal. You only know a range of judges who may hear your case. And that has massive consequences on the front end for how you even frame your issues on appeal. Second, trial court writings must convince one person to do something in the first instance. There are facts and law, and you have to mount the better version of the facts given the articulation of the law you offer. You're not required to overcome deference to any state of affairs. It's a clean shot you take. Appellate writings, however, you now have to convince 3 jurists from different backgrounds to undo, when you're the appellant, undo the reasoning and work of another judge, and to undo it when there's often a legally mandated amount of deference to be given to the decision. That's right. A whole range of trial court decisions are given deference, such that an appellate court may look at what the trial court did and say, hey, if I were the trial judge, I wouldn't have done that. But it doesn't matter because reasonable minds can differ. And so even something that I may have done differently, I'll still affirm it as an appellate judge. That's a big difference. Third, trial courts expect without reservation multiple theories and approaches to get through pretrial and then to get to your jury. And advancing innumerable theories is simply not fatal. But appellate courts, they don't expect or even tolerate myriad alternative theories and claims. And the same approach that yields success often in the trial court condemns you to failure in the appellate court system. Fourth, trial courts routinely grant significant time to discuss law and motion orally. I've had the experience in the trial court of arguing a large trademark case at summary judgment, where the trial court allowed 2 hours of argument spread out over an entire day, from 8 a.m. until late at night. And that time was needed. But appellate courts jealously limit you to 10, maybe 15 minutes to discuss the same issue with 3 inquisitive minds. And on appeal, that can be done, as we'll discuss soon, given a deep understanding of how your written work product is assessed before you even show up to talk about it. But you have to know how, and that's why an appellate lawyer is critical. These root differences have a profound impact on appeal in terms of what you should write, how you should write it, and what you should do at oral argument in an appellate setting. So, from this foundation, let's get to winning your appeal with some key insights and deliverables. The first issue I want to discuss falls under the rubric of credibility. You must understand how the currency of credibility on appeal is so different to the trial court. An exchange rate exists between the two venues, and if you don't know it, you're falling short in what is needed to prevail. Let me start with this quote from United States Supreme Court Justice Robert Jackson, penned by him in an article decades ago, a quote that holds true today. Legal contentions, like the currency, depreciate through overissue. The mind of an appellate judge is habitually receptive to the suggestion that a lower court committed an error. But receptiveness declines as the number of assigned errors increases. Multiplicity hints at lack of confidence in any one. That is a cardinal principle. This critical relationship between credibility and assigning error cannot be overstated. Like it or not, right or wrong, fair or unfair, there simply is an inverse ratio between the number of assignments of error you make and your very credibility on any one issue you press. Myriad assignments of error simply dilute all claims to the point that a good argument can be drowned in the cacophony of assigned errors. Now, in the trial court in a breach of contract case, people routinely assert claims for breach of contract, unfair business practices, and other tort claims, trying to skin the issue as a tort too. When that complaint is filed, the trial court doesn't look at it and assume that it's meritless or that it's thin because you have myriad theories. But on appeal, if you press those same alternate theories, you instantly damage your credibility. That means that if you have in the midst of all the theories one good one, you're likely to hinder the appellate court's willingness to even see that as an error because you've said everything was an error. So what does this mean for you on appeal? It means no matter how much you think the trial court erred along the way, you have to limit your choices to assigning error in a few instances. If you are telling the appellate court that the trial judge literally could not do a single thing correct, we've all been there, I get it. But if that's what you're saying, then you've already lost your audience's receptivity to consider any given action as being one imbued with error. And you've doomed what could be a winning argument to a losing one. By assigning too many errors, you've fallen off the sliding scale. Think about this from a practical perspective. Trial court decisions, they're presumed correct as a matter of law. But that, of course, is a legal fiction and structure that we work with. Let's put that aside. Let's understand the very practical nature of the court system you're now in. At a practical level, the appellate judges know the trial court judge. They know the trial court judge, having reviewed myriad decisions of that judge, where, remember, statistically, they've affirmed 90% of the time. Pause on that. That shows they know the trial judge can do things correctly and does so most of the time. But they also know the judge personally from conferences and court events. So at the street level, they can't believe the trial judge is just an idiot incapable of doing anything correct. And if your narrative presses that, which it does when you assign too many errors, then you've lost your audience before you even begin. The appellate judges practically know the trial judge gets things right most of the time. So if you're delivering to them a narrative fatally at odds with their root understanding of the trial judge, then you've instantly lost your audience. This is where appeals are most often lost. Out of the gate, in the opening brief, where the message delivered is that you were right and you were sidetracked by some bumbling idiot below. Instead, you need to assign scant errors, and the judges are then perfectly willing to believe that this judge they know made a mistake. To err is human, after all, and judges recognize they all make mistakes on occasions. And when appellate judges see an appeal, the first thing they look at and see is who was that judge below. And the next thing they should see, if you're doing it right, is that this judge simply made a mistake, an explainable mistake within the narrative of your situation. Now, this is staggeringly hard for a trial court lawyer to do, for its own systemic reasons. Trial lawyers really believe in their theory, they pressed it below, and they were paid to do so. And this is not to say they were wrong, they weren't. But they were operating in a different system where that approach was fine. To recognize such a foundational shift in approach is hard, and it often creates tension. Sometimes when I work with trial counsel in a handoff situation, it's obvious they fear being second-guessed. And it's not a question of second-guessing them or their decisions. It's a question of understanding the rules of the new venue that you're in. After all, it is hard to suddenly have to abandon ship on things that one firmly believed in. It feels like defeat or failure, but it's not. It's actually wise strategy for appeal to focus in on a few key errors that fit a larger narrative. This currency of credibility posits a firm exchange rate. You may not like that exchange rate, but it exists from the moment you decide what you even tee up in your written brief at the outset of your appeal. You innately want to resist the exchange rate. It feels wrong or unfair. But if you don't abide by it, you will find your pockets empty in your appellate transaction. Knowing how to maintain maximum credibility and assign the right errors, that's how you win an appeal. And you do it by talking to lawyers who do that exchange rate for a living. Let's move to the second key lesson for winning your appeal, and it's knowing your audience and the controls placed on them. We're all used to trial judges, especially life-appointed district court judges that can do almost anything they want in their cases. There are judges who might make you come to court late at night for argument, no joke. I clerked for a district court judge also, and I'll never forget her describing the awesome power of a single lone person, a single judge. She said, on a preliminary injunction motion, given the facts and law at issue, she could order the Navy to blockade a port. Think about that. They have staggering power, seemingly limitless power, and they sit alone. And lawyers cater to that, aware of it and cautious how to tread around it. But appellate judges are actually fenced in by controlling principles independent of the issues before them. And they sit in a group, 3 of them together, sorting out decisions so you avoid some of those ego issues that lone judges have. There are these external fences, then, that uniquely control their ability to act. To win on appeal, you must understand what these fences are and know how to get over them. The most basic one is the standard of review. This is the prism by which they must review the trial court's behavior. And legally, they are required in a whole range of cases and issues to grant deference. They must, even if they would have done it differently sitting in the trenches, they must still defer to the judge in the trenches if the action falls within a range of reasonableness. So, for you as an appellant, this poses a staggering problem on appeal. Those judges may disagree with what happened below, but they legally still have to affirm it. So the key move an appellate lawyer makes when confronting these mandatory grants of deference to trial courts is to find a creative way to reframe the issue, to unpackage what happened, and to frame it in purely legal terms. Because if you can reframe that mistake from one that involved permitted discretionary behavior to simply an error of law, then you've freed your audience from deference and restraints. That's called de novo review, and it's the holy grail of appellate lawyers to find a means to unbridle your appellate judges. Appellate lawyers work with the law in creative ways to address the deferential death kiss, by reframing matters within bodies of law or by addressing the legal framework at varying levels of abstraction. And these are skills appellate lawyers develop. They're skills that trial lawyers don't even necessarily need. as they don't face the institutional bias or deference against an outcome. Now, there's a related massive legal principle you must understand and work with, one that's not present in the trial courts. There's now a winning party, and there's a legally mandated bias in favor of that winning party. The trial court, of course, is the opposite. There's no bias in favor of the plaintiff and against the defendant just by virtue of filing a lawsuit. But now on appeal, simply by filing an appeal, you confront a legal bias against you as the filer, a systemic legal predisposition to actually think, all else being equal, you're wrong. Pause and consider that. No such predisposition exists in your trial court case. That's written on a blank canvas. And so this requires, again, creative lawyering to address the error within the amount of required deference to overcome that systemic bias. There's also a third fence here, a showing of prejudice to justify reversing something that a court may think and agree is wrong. Showing an error alone is not enough. You must actually show the error prejudiced you. In other words, errors are actually fine to appellate judges. People err, after all. It's errors that harm you that matter. So working around these fences, it's everything. Being right's not enough. Being right in the right way. That's what appellate lawyers must do. And that's the second insight today about why you need appellate counsel when you go on appeal. There's a second component to appellate lessons that flow from understanding your audience. It's how to write your brief to an audience of 3 judges whom you don't know. Remember, you know your trial judge. Here are briefs. They're filed months before you know your audience on appeal. What does this mean? In 20 years and scores of appeals, this has led to another critical insight. You must find a way to frame the error below in process-oriented terms. What do I mean by this? If your pitch is that the substantive fairness of a rule or outcome goes your way and not the other way, then you'd better draw a panel of judges who share that policy or political preference. If you don't, you're dead in the water. And because you don't know your panel, you take a massive risk if that's your root argument. But if you can find a way to frame the error below in terms of a failed process, then you've built an argument foundation that jurists of all political or policy persuasions, they can agree with. Whether conservative or liberal, my experience has been that judges of all stripes want a fair and a balanced process. And so arguments built in that light, those arguments appeal to the widest possible audience of who you may get as your judge. Let me give you a concrete example of this. Years ago, I had an appeal. It was on behalf of an immigrant whose immigration case was thrown out of the immigration courts because she didn't file a timely notice of appeal within the immigration court system. There was a massive issue of the substantive fairness of expecting my non-English speaking client to be able to, pro se, file appeals on certain forums within certain deadlines, checking the right boxes, etc. But waxing on about the need to help those people struck me as a dangerous gamble because I didn't know my audience. So I found a way to work with the law to posit that the government form was itself infirm for everyone, not just non-English speaking immigrants, but for government lawyers also who wanted to file their own appeals. And the error was in how the form was written. This triggered the ability to argue into procedural due process law and argue that there was a form problem as opposed to this particular person having been treated unfairly. It was a pure process-oriented argument. I got a conservative panel when I got to my oral argument, and normally in that type of case, I'd be worried. But I won, and I got a published opinion from a very conservative jurist writing about the need to guarantee procedural due process. I'm quite sure, indeed I'm certain, that if I'd framed the argument through the lens of substantive fairness principles, with that audience, I would have lost the appeal. This need to find the process-oriented error that reaches the widest common denominator jurist is something I teach my students every year in every case. And I tirelessly force myself to work on building my legal arguments for my clients on appeal through that very prism. That's another cardinal principle of appellate advocacy that you must know, or else you'll run head-on into it and you'll take a massive risk with your appeal. The third lesson today is about appellate oral advocacy, what to do and critically, what not to do. In the trial court, you're routinely given ample time to address everything you want to. The trial court even invariably asks if there's anything else you want to say. Now, they do that because they want to show the appellate court they gave every indulgence to you before they ruled against you. That means one thing. Trial court lawyers can appear and argue every little point, hoping to find something that sticks. But in the appellate court, you now have almost always 10 minutes of time to say what you need to say. This means that even once you've filed your briefs, narrowing the issues, remember, as we discussed earlier, a hard thing to do itself, you must now do it again. And you have to narrow your discussion from your briefs that may have raised 3 or 4 issues down to 1 or 2 issues for oral argument. And you need to do it in a way where you control the clock, your 10-minute clock, and where you don't get sidetracked on matters that don't matter. Let's take this apart with an example. Imagine, hypothetically, we have a case where you have an appellate brief that raised 2 main issues. You have a copyright issue and a trade secret issue. The copyright issue involves 2 components: whether the work meets the originality standard and whether there was even substantial similarity between the plaintiff and defendant's work. And the trade secret ruling you're appealing raises 2 sub-issues too: whether the matter was even a secret and whether it had independent economic value. 2 main issues, but really 4 sub-issues overall. You have 10 minutes. You need to hold 2 to 3 for rebuttal, so you really have 7 to 8 minutes to talk about this. And you're talking to 3 judges. You cannot effectively discuss both the copyright and trade secret issues and their 2 subpoints each. You can't do it in 10 minutes, let alone 7 or 8, without doing a disservice to all your issues. You can't do it. This is a cardinal mistake made by trial court lawyers who argue their cases on appeal. They just can't accept that they can't talk about everything. But you have to. And that requires being comfortable that some of your arguments, they stand or fall on the briefing. No further words. So you have to now decide what you let stand on the briefing and what you're going to address at oral argument. This itself requires an act of applying our currency of credibility. Why is this important? Because almost every time you argue an appeal this way and make clear what you are addressing, you eliminate a judge taking you away from your point to another point, and you get their buy-in to the discussion being around what you want to talk about. This lets you focus deeply on what you need to focus on and substantially reduces the likelihood the judges sidetrack you on other issues. Let's illustrate this by assuming you have not narrowed your oral argument presentation focus, and so you, having argued the case in the trial court, get up to argue it on appeal, and you're there to argue everything. This is then what happens, and it's bad. May it please the court. Peter Afrasiabi, counsel for appellant. The lower court erred in its summary judgment on the copyright issues of originality and substantial similarity and the trade secret issues of secrecy and independent economic value. The trial court ignored lots of evidence, made wrong evidence rulings, misunderstood how California state law on trade secrets works. It also confused federal copyright standards between the circuits, blah, 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 blah. Note, you actually still haven't even explained what the error was and why you're standing there before these 3 judges. But now you get a question on originality, and so you start answering it. And another judge says, well, what about the similarity issue, and where's the evidence of that? So now you're ping-ponged over there, and you start answering that, never having finished your originality point. So you answer the question, and you pivot back to answer that. But they want to stay on similarity. And then a 3rd judge wants to discuss trade secret. You see where this is going. You can't really unpackage any issue without being tossed around between all the issues. So you never say a lot about anything in particular, and you never feel satisfied. Oral argument is always about handling being a ping-pong ball to some extent. That's the innate nature of it. You got 3 judges asking you questions. But you've allowed yourself to be a ping-pong ball in the Olympics of ping-pong, getting bounced around endlessly across myriad topics so that you can never make the really core points you want to make on the one issue that matters. This is why you routinely hear the refrain from trial court lawyers who go up to the appellate court that the court just didn't listen. They didn't get a chance to say everything they wanted. They just got questions and no one would listen to them. It's true. They didn't say what they needed to. But that's because they didn't go prepared to say only what they needed to say. They appeared wanting to say too much. It's like the old adage about showing up with a knife to a gunfight. You can't show up to oral argument to discuss your brief. You're there to discuss a subset of stuff in your brief. If you've been through this process nearly 100 times, you know that you must choose just a few points and augment them from the briefs and illuminate them from the court. The true pivot points on which your case turns. Points you've decided are worthy of your 7 to 8 minutes to really amplify and augment them from the court, to show the error below divorced from everything else. And then you don't leave ever feeling that you're aggrieved and you weren't heard. I can honestly say I've not had an oral argument in the last 15 years where I felt time was so short that we lacked the time to say what was needed to be said. Getting to this point, however, that requires sticking with the currency of credibility. So now let's take our same hypothetical case, and let's do it in a manner that allows you, as much as possible, to control your clock and the dialogue. This is done by being laser focused on what the error is and what you're there to talk about and what you're not there to talk about. It would go something like this. May it please the court. Peter Afrasiabi, counsel for the appellant. There are two core issues in this appeal that I will address today. One, the lower court erred in light of the minimal creativity standard adopted by the Supreme Court when it concluded the design of the device at issue lacked originality because there were multiple aesthetic options. Second, the trial court erred in concluding that the designs were never treated as a secret, disregarding the NDAs and the employment agreements that provided for secrecy. Turning to the first issue on originality. Okay, so what we've done here is the following. First, we've told the court what we aim to address succinctly in the first 30 seconds. Second, we've said what's off the table from our perspective. Only 2 of those 4 issues on our slide, we've said the other 2, they can stand on the briefs. Now, that doesn't, of course, guarantee the judges won't ask about the other 2 sub-issues, but I'll tell you, almost 90% of the time in my experience, it has that exact effect. That means one thing. You've now helped make sure that your limited time can be used on only what matters to best have the chance of winning. Third, the other thing you've accomplished is that you've identified the 2 core issues. The USB possessed some minimal creativity, and the design plans were under an NDA, so they were secret. And you've explained in those immediate 30 seconds why the court should reverse. That means in 30 seconds, the court knows the core of the appeal, the root error, and how you're going to win. Collaterally, you're more likely to draw questions only on those issues, and that allows you to make the many subpoints you want to make about those issues to really drive home why you should win. So, if you remember the first example, when I did the hypothetical oral argument, there was a long wind-up about the whole case, what happened below, all sorts of issues on evidence, and really those first 30 seconds were wasted without giving a roadmap that limited the discussion to a narrow topic and without identifying even the exact error and the exact basis for reversal. And that argument, that's the typical argument given all the time in the Court of Appeals, and it eliminates the ability to control the dialogue and to make an effective presentation. Narrowing your playing field with this roadmap almost always, in my experience, causes judges to not burn up your clock on the issues you set aside. Sometimes they still ask, and that's fine. But most of the time when that has happened to me, I used my clock on what mattered to me, and then they tell me they have other queries about the other issues, and they actually gave me more time to address those additional issues. In essence, they treated the other issues as being off-the-clock type issues. That's a massive win, because now you've actually secured more time to stand before those judges and press your case. So here's the skill, my deliverable to you. At oral argument, you must, in 30 seconds, identify the root error upon which your appeal hinges and upon which reversal must occur. If you can't do it in 30 seconds, you've not reduced your case to its essence. But my case is too complicated, it requires more time, it's just too difficult. I hear it all the time. No, it's not. If you require more time to distill the essence of your case, then you've not figured out the essence of your case and the issues at play. That's what we appellate lawyers do. Every appeal can be explained and articulated in terms of this roadmap and distillation of error in 30, maybe 45 seconds. It's done every single time by hewing closely to the currency of credibility. I hope that if you leave this presentation with one clear concept in your mind today, it's that going on appeal is not simply another step in the litigation process. It's a new court, with a new center of gravity and a whole new set of rules. It may look like a similar court, but you've really moved into a new orbit around a new planet, even if you're in the same solar system. Today I shared some of the means by which credibility works in the appellate system and some of the different structural headwinds you confront. I've shared some critical insights and guideposts so that you can maximize your odds of succeeding in the appellate system. But there are more critical principles that animate the appellate universe. Some involve things as minor as introductions. The appellate rules generally never require one, but do you write one anyway? And if so, to what end? And how short should you keep it? And how does it serve the narrative of your brief? Other questions involve much grander issues about the nature of justice from the appellate court. The trial court, of course, only cares about who wins. Plaintiff, defendant, has little precedential effect. But the appellate court, it's making law for tens of millions of people. This role of the court then casts a shadow on everything it does, and that impacts you and your appeal. Appellate lawyers therefore have to confront and understand how this one case fits into larger concepts of justice, and whether this appeal is about justice between the parties, or is it really about justice for a larger jurisdiction, and the two may be at odds in any given case. How do those two issues reconcile, and how do you harmonize them? All these appellate principles are what appellate lawyers grapple with, ponder, day in, day out. Winning on appeal is never easy, but it can only be done if your lawyer knows how appellate justice operates. Thanks for watching.